Good morning to all of you. Dr. Georgios Petrochilos is, I would say, a truly Greek success story in the international arbitration community. But he's also a victim of the arbitrator's unpredictable life. So a professional, unpredictable engagement prevented him from being here in person. George is going today to redefine the concept of arbitrability.
Ladies and gentlemen, colleagues, good morning. I stand before you added, not so much out of concern to fear of attacks on person of attention, though this can be concerned, but because I am stuck in a very long hearing that exceeds scheduled duration. I'm afraid excessive duration ground of non-arbitrability, and so I am grateful to the organizers of the conference for allowing me to appear in a recorded manner. Let me start by saying that it is feasible for a practitioner to have a long arbitration without once stumbling upon an objection to arbitration. Such objections are rare nowadays, almost completely out of fashion. And the reason for that, straightforward, very much has been done in the 1960s, 90s to diffuse, in very great part, objections to the ability of a case or the ability of a litigant party to be amenable to arbitration. And so arbitration became much more mainstream than it would otherwise have been. Indeed, the expansion of the scope of what is arbitrable and who can arbitrate was pivotal in taking arbitration outside the traditional historical fields of construction, shipping, and trade dispute. But when an objection to arbitrability is almost like a black swan, it never fails to cause great excitement. Why? Well, for one, non-arbitrability operates in guillotine. Successful, it is entirely dispositive of the case, which cannot go forward the merits. For another reason, there is always an interesting debate to be had as to how we should characterize a particular objection to arbitrability and consequently which law to apply to resolve it. Both of these reasons suggest, and very strongly so, that a primary interest in dealing with arbitrability lies in understanding its proper limits and defining it accordingly as a matter of legislative policy. This is, of course, topical in revisiting and revising Greek arbitration law, as we will almost certainly have to do in the near future. It is fair to say that arbitrability, or rather non-arbitrability, is an omnibus term which refers to reasons for which a dispute is not capable of settlement by arbitration. These are the terms employed by the New York Convention in Article 2, Paragraph 1. This, it can be either by reason of its subject matter or by reason of the parties to the arbitration. When the reason goes to the subject matter, one speaks of subject matter or objective inarbitrability, and when it goes to the parties to the arbitration, one speaks of subjective inarbitrability or non-arbitrability. Now, let me pause here. Why do we need a special legal category, arbitrability, to pigeonhole a particular defect of the arbitration agreement? The reason for this is simple to grasp. In fact, arbitrability impediments do not call into question the intrinsic validity or the legality of the arbitration agreement. Still less do they call into question the validity or the legality of the substantive contract of which an arbitration clause forms part or to which the arbitration agreement relates. Rather, arbitrability impediments are special beasts in that they raise a barrier to arbitration as an appropriate forum to resolve the dispute, or, which is to say the same thing but looking at it from the other end, to put forward another forum with exclusive jurisdiction to resolve the dispute. And so no broader claim to the validity or to the effectiveness of the arbitration agreement is being made. Now, because arbitrability is a special problem in the way I have just described, it raises the question whether it should be dealt with as just a species of the general category of validity of the arbitration agreement, so for subject matter arbitrability, or of the general category of personal capacity, so for subjective arbitrability. And as we will see, this question has a direct impact on which law or laws are applicable to determine questions of arbitrability. Today, I propose that we look at three main issues. The first issue is to consider whether the notion of arbitrability should cover both objective and subjective arbitrability, and I will suggest that there are no compelling policy reasons for maintaining impediments to a person's capacity to submit to arbitration. I will suggest that while certain classes of persons should be protected, these protections should be formulated as pertaining to the subject matter of the dispute, not in relation to the persons in themselves, and that therefore subjective arbitrability should be an exhibit in the arbitration museum. To the extent, however, that impediments or restrictions to one's capacity to enter into an arbitration agreement are still around, there is a good practical reason for keeping them in a legally separate category from other issues that can affect a person's capacity. The second issue is how best to define which disputes can be submitted to arbitration and which cannot. My submission will be that if we need a statutory definition at all, and to my mind at least it is an open question whether we should, then arbitrability should be defined in a broad manner. More importantly, the exceptions of non-arbitrability should be defined in as specific terms as possible. The third issue for today relates to applicable law. I will suggest that arbitrability should primarily be determined by reference to the law governing the arbitral process as the whole, or lex arbitri, which is basically to say the law of the seat of the arbitration. Other countries' laws may come into play only at the stage of recognition and enforcement. So let me turn to address each issue in turn. As I said earlier, the notion of arbitrability or non-arbitrability seeks to capture impediments to the validity or to the effect of an arbitration agreement, which arise exclusively because the agreement provides for resort to arbitration and for no other reason. Two consequences flow from this. The first consequence is that non-arbitrability should be capable of being defined in advance in the law. It is a discrete, narrow exception which strikes only at a particular aspect of the parties' agreement to arbitrate. The second consequence is that arbitrability impediments are jurisdictional in nature and in their effect. They operate at the threshold, one might say in limine litis, and they preclude consideration of the case on the merits. Now it follows from this that one may not speak of a non-arbitral dispute by reason of, for example, the illegality of the underlying transaction. And so the well-known award by Judge Lagergren in ICC case 1110 of 1963 has been rightly criticized for holding that a contract entered into for a corrupt purpose was not arbitrable. The correct position is that no claims can be founded on a corrupt contract. The contract has to be recognized as illegal and the claims thrown out, as was held, for example, in the well-known World Duty Free and Kenya case, which concerned a contract for a lawful purpose but entered into through bribery. To say that an arbitral tribunal cannot determine the illegality of a contract and cannot throw out the claims founded on it would be to deny that arbitration is a forum that can uphold the rule of law. There is also a caveat to be made. Arbitrability objections operate jurisdictionally, as I said earlier, and therefore they have to be raised at an early stage of the proceedings. An example is Article 23, Paragraph 2 of the Arbitral Arbitration Rules, which requires such objections to be raised at the latest with the first round pleadings of the objecting party. If the objection is not made in a timely manner, it is foregone. Now, this conventional analysis, which has been applied by a number of courts over the years, stands in tension with Article 34, Paragraph 2, subparagraph B, under Roman 1 of the Arbitral Model Law. This provision permits a court to set aside an award of its own motion and without a request by the parties, on grounds that, and I quote, the subject matter of the dispute is not capable of settlement by arbitration. Essentially, subject matter arbitrability is dealt with in the same way as contrariety to public policy, which can also be controlled by the court of its own motion. Now, there are two possible ways to resolve the tension. The first is to say that subject matter arbitrability is a special kind of jurisdictional objection which cannot be waived. This would then mean that arbitrators are to satisfy themselves in respect of arbitrability quite independently of the parties' pleaded positions. The second approach would be to say that this kind of objection can be waived, just like any other objection, and that the only difference is that the controlling court can, but need not always, and that's the key point, examine arbitrability, provided that it has been raised as an objection in the underlying arbitration. Obviously, the first approach is easier to argue. Now, with these points of principle in mind, let us turn to consider what is and what is not arbitrability, starting with the so-called subjective arbitrability. In conceptual terms, it is very straightforward to define this category. It comprises impediments to resorting to arbitration that attach to the parties by reason of their status. First of all, in order to conclude that such an impediment actually exists, one has to consider the relevant law. Let me take an example. The law of Kosovo contains a rule that disputes with a privatization agency arising from privatization contracts have to be submitted to a special chamber of the Kosovo courts. It was suggested to an ICC tribunal that this law operated to exclude arbitration. The tribunal, sitting in Switzerland, disagreed for a number of reasons, holding that the purpose of the law seemed to be to create a specialized jurisdiction within the Kosovo judiciary. That is to say, a rule applicable only if the Kosovo courts were competent to hear the case in the first place. And so it was not the effect of this law to exclude resort to arbitration. This is indeed a cautionary example in a broader fashion that a law may create a special judicial formation or may provide for exclusive jurisdiction in respect of certain cases, does not of itself mean that resorting to arbitration is impermissible. and we will come back to that point later. And so when one asks the question, what kind of persons should not be allowed to vindicate their rights in an arbitral forum, even if they agree to do so by a written contract? It is difficult to give a cogent answer other than for a very limited category of persons whom I suggest we get out of the way quickly. Consumers should be protected from having to arbitrate small-scale disputes arising from consumer contracts, especially when the relevant arbitration agreement is part of standard contract terms that have not been negotiated individually. There are two reasons for this, and they are interdependent. The first reason is that consumers don't look at what they sign, just like you don't look, I will bet, at the terms of contract that various internet apps ask you to click accept to before you download the app. The second, more important reason, I should think, is that the cost and the hassle of arbitrating a consumer complaint are disproportionate. The arbitration agreement serves practically as a disincentive to enforcing consumer rights, and so consumer contracts for modest amounts are dealt with by special legislation, which should provide for consumer-friendly, economical, and swift processes. And so we can take this kind of dispute out of our minds. And by the same token, we can take out of our minds some labor disputes or disputes within labor unions, or in some countries, disputes between professional athletes and clubs, all of which types of disputes are typically subject to special procedures, including compulsory arbitration, again, on grounds of cost and swift determination. So, who else can be exempt from arbitrating what they wish to arbitrate? Well, no one else. And forgive me for putting this provocatively, but it is quite on purpose. One might think that public organs or agencies should not be allowed to arbitrate differences relating to their administrative acts, and that such disputes are only for the courts to handle based on special public law causes of action and remedies. And one instantly sees how this is a reasonable policy decision, and indeed most civil law countries follow this policy. But it is a policy that flows from the public law nature of the acts in question, not from the fact that there is a public organ or a public agency involved. Indeed, it is quite trite that state organs and state agencies can arbitrate, for example, procurement contracts that they have concluded. So arbitrability limitations of this kind are to be seen as attaching to the subject matter of the dispute and not to the litigants themselves. Now, this type of limitation having also been put to one side, what else remains? Not much, or at least not much that can be seen as justified on compelling grounds. From time to time, one encounters national laws to the effect that state organs and agencies require special advance authorization before they conclude an arbitration agreement. Iranian law contains such a rule in the Constitution, and Greek law contains such a rule in the statute that regulated the entry into force of the Code of Civil Procedure in the 1970s. I hasten to say that Greek law contains multiple statutory exceptions, notably for public works contracts and for international contracts, but let me put those to one side and address the issue as a matter of principle. Question number one: are such restrictions, or rather preconditions to arbitration, exportable? Can they be validly relied upon in an arbitration which is seated in another country? Answer: no. And there are multiple arbitral awards from the 1980s to that effect, such as Benteler and Belgium, Hamatom and Iran, and ELF and the National Iranian Oil Company. How does one get to this result? The answer is it depends. In some countries, such as Switzerland and France, the law altogether precludes such arbitrability objections. But apart from such drastic solutions, the main methodological point is that if one treats arbitrability as a category, distinct from the capacity of a party, one can submit that question to the law of the seat, rather than to the personal law of the party in question. In terms of the model law, the issue would be dealt with under paragraph 2b of Article 34 of the model law, rather than under paragraph 2a. And so practically, one can say that by agreeing to seat the arbitration in a third country, the parties effectively agreed that such restrictions will not operate. Question number 2. What if the question or the issue is to be treated as one of capacity? Or if the seat of the arbitration is a country which contains similar restrictions for the agreement to arbitrate, or is indeed the very country of the state entity that objects to arbitrability based on its own law? The outcome, that is the answer, should not change. Why? Because preconditions to arbitration are internal matters for the relevant state organ or state agency to attend to, such that if the organ or entity fails to attend to them, there may be disciplinary consequences and the like, but the innocent counterparty remains unaffected and the arbitration agreement stands. And that is indeed the approach of the Greek courts since the 1970s. Question number 3, and that is a broader question. Are such restrictions justified in the first place? Answer: there is considerable authority for the proposition that they are not, emanating in particular from the Institut de droit international. On the other hand, it is legitimate for a state to be able to control which disputes can generate the kind of expense and specialized expertise that an arbitration, especially one seated abroad, demands. But legitimate as this objective may be, it does not suggest that it should impact on third parties. The various state authorities involved in the authorization process should follow it properly, and the state should focus on that being done in the first place. It's the state's responsibility to do so, and nobody else's. I now come to restrictions to arbitration deriving from the subject matter of the dispute. This is the so-called subject matter arbitrability, which is recognized as a specific category of validity under the modern law, mirroring the approach under Article 5, Paragraph 2a of the New York Convention. Let me give you briefly the lay of the land before my submissions to you. 3 points. The first point is that subject matter restrictions may arise from the outset, or they may arise, that is to say, ab initio. Such is the example of disputes about the validity of administrative acts, which I mentioned a few minutes ago. More rarely, restrictions may also arise subsequently. For example, a foreign investor for whom his or her state of nationality has exercised diplomatic protection and obtained redress will be barred from pursuing claims under a pre-existing arbitration agreement with the host state. Such claims are extinguished by operation of international law, both substantively and jurisdictionally. The second point to note is, again, that there has to be some genuine obstacle to resorting to arbitration. Provisions of domestic law relating to exclusive jurisdiction of some courts do not, of their own, entrain non-arbitrability. And it is regrettable that not all laws specify this, because courts of specialized jurisdiction exist in several countries and for good, obvious reasons. The exclusive jurisdiction of such courts may well preclude other courts in the same country, or even abroad, from being seized of a case. See the Brussels regulation. But it does not necessarily follow that it is not possible to submit the dispute to a different forum altogether, namely arbitration. The Malaysian, New Zealand, and Singaporean arbitration statutes helpfully spell this out, but not many other laws do so, and this on occasion leads to trouble, especially in disputes relating to real property rights. The third point is that national law may define arbitrability through an affirmative definition, or it may do so through exceptions or limitations to arbitrability, or, as is in fact rather common, a combination of the two. And when one considers this matter of legislative technique, one is rather struck by the fact that the drafters of the ancestral model law, notwithstanding considerable effort, were unable to reach consensus on an affirmative description of which disputes are arbitrable. You can see that in Article 1, Paragraph 1 of the model law, which refers to commercial disputes, without further particular. And then there is a footnote which says that, I quote, the term commercial should be given a wide interpretation so as to cover matters arising from all relationships of a commercial nature, whether contractual or not. Now, let us pause here and consider other legislative texts. Broadly speaking, one finds two types of approach. The first approach is to set out an affirmative definition in broad, very conceptual terms, and this is very much the traditional approach in civil law jurisdictions. Typically, the definition speaks of subject matters or rights that are within the party's free disposition and can be made the subject of a private contract, or legal entitlements which the parties can settle, or both. Now, this kind of definition tells us, in fact, very little that is concrete and is basically dynamic in nature. It is to say that parties are free to arbitrate disputes that involve nothing more than their private interests, and to leave it for the courts to work out, over time, which disputes fit this bill and which do not. And so, over time, a further requirement was added in several laws, namely that the dispute must have an economic or proprietary or commercial nature. This serves to exclude disputes about personal status, such as family law rights and, in some countries, succession. There is no question, of course, that the rights involved in such disputes are private and that they can be waived or indeed settled. But there is some other policy reason which suggests that they should not be arbitrated. The reason is not stated in the law, and so it has to be worked out by the courts. And this, of course, raises difficulty when a dispute is mixed, that is to say, when it involves the economic consequences of an anterior dispute about status, for example, a divorce settlement or an agreement among heirs for the management of a jointly owned asset. Now, these difficulties strongly suggest that the criterion we seek to identify for arbitrability has less to do with the nature of the dispute and more with the range of persons that are affected by the disposition of the dispute. What one opposes is that disputes which admit only of an erga omnes resolution, valid for all, and remedies which also might operate vis-à-vis society at large and a large number of persons, should be resolved within the bounds of an arbitration that involves a limited number of parties. Now, let us bear this in mind and return to it a little later. The second approach to definitions is to say nothing, or almost nothing, about the kind of subject matters that may be arbitrated, and rather to set out specific exclusions or prohibitions by statute, sometimes a specific statute, unrelated to arbitration. The New Zealand Act is emblematic of this approach. Section 10 of the Act provides that a dispute is arbitrable if the parties have concluded an agreement to arbitrate and there is no prohibition of public policy to arbitration. The Singaporean and the English Acts are along the same lines. Now, this kind of definition does not tell us very much about the kind of public policy that might prevent arbitration. And there is a further difference with the first legislative approach, which we looked at, and that is that the onus of proof, as it were, is reversed. It is on the party who opposes arbitration to show that there is a public policy prohibition. It is not on the party who moves for arbitration to show that the case is indeed arbitrable. Now, both of the approaches we looked at are inching towards identifying the limits of arbitrability, but they are not spelling them out in comprehensive terms. The Dutch Arbitration Act does attempt to do this. It provides, and I quote from Article 1020, paragraph 3 of the Code of Civil Procedure, that an arbitration agreement may not serve to determine legal consequences of which the parties cannot freely dispose. Now, there are two salient elements here. First and foremost, the focus is on the disposition of the claims, that is to say, the remedies and the effect of these remedies. Secondly, and this follows from the first element, a dispute can be in part arbitrable and in part non-arbitrable. Now, what Dutch law does in these comprehensive terms, one can see at play in more discrete cases, which I should like to outline for you. A number of laws, the English Act of 1996 is a good example, prohibit arbitrators from ordering specific performance that could alter title to land. Why? Because the effects of such an order would be erga omnes. A number of laws, Swedish law and US federal law are good examples, make it clear that the private law inter partes consequences of competition law issues can be arbitrated. What cannot be arbitrated is fines for breach of competition law, which only public authorities and the courts may issue. The same applies to tax disputes. In most jurisdictions, including Greece, disputes with the tax authorities in respect of tax liabilities cannot be arbitrated. But disputes about the economic allocation of tax liabilities or the contractual consequences of tax liabilities may well be arbitrated, both as between private parties and as between a private party and the state. A number of laws make it clear that matters of personal status, such as divorce, filiation, death, and the like, are not arbitrable per se. But again, it is difficult to see why claims that are attendant upon status, such as a claim for breach of a divorce settlement, should not be arbitrable. In the same way, disputes about the validity or the rectitude of patents and the dissolution, the bankruptcy and reorganization of companies, to the extent that they may have erga omnes effects, are also to be regarded as non-arbitrable. And so one can see that the appropriate focus is on the consequences and the breadth of the disposition of the case, rather than solely on the nature of the rights involved, or still less, the type of relief, monetary, declaratory, and the like, that is being sought by the parties. One can also see that the fact that exclusive jurisdiction may vest in some court or in some authority, for example, a patent court or a competition authority, is not of itself dispositive of the question of arbitrability. And finally, one sees that it is not helpful to suggest, in broad terms, that disputes involving elements of public interest are not arbitrable. It is fair to say that cases whose effects extend beyond the circle of litigants or involve the exercise of public powers, such as competition law penalties or taxation liabilities, involve the public interest by definition and in a pronounced degree. But if one starts from the other end, looking for cases which involve public interest in an abstract and sweeping way, there is a good chance that the range of non-arbitrable disputes will expand very considerably. And this last point is borne out by the jurisprudence of the European Court of Human Rights, and before that the European Commission of Human Rights. A number of cases, starting from the 1970s, has dismissed claims that certain subject matters are not arbitrable under Article 6 of the Convention, and thus employment disputes and the like have been held to be arbitrable, to the point where a commentator was able to say that, and I quote, the European Convention has no view on subject matter arbitrability. It is true in that context that the court has reserved their position for cases, and I quote again, involving issues of public interest which would make an arbitration inappropriate or unreasonable. But so far, the court has concluded this to be the case in one very rare set of circumstances, namely a large-scale nationalization. And there, the court said, it was reasonable to bar recourse to arbitration to avoid what the court said would be, and I quote, a multiplicity of claims and proceedings brought by individual shareholders. So to conclude on this issue, the emphasis in the past decades has been mostly on placing responsibility on the shoulders of arbitrators to see to it that mandatory law, competition law in particular, is observed. On the one hand, arbitral jurisdiction is preserved rather than being barred, and on the other hand, the mandate of arbitrators is confined to holdings that are strictly as between the parties and which exclude penalties and other sanctions which only state authorities can impose. Decisions such as the Mitsubishi case in the United States Supreme Court and the EcoSuisse case in the European Court of Justice are milestones in that direction. Before I leave the topic of subject matter arbitrability, I ought to say a few words about two special cases which are cognate with arbitrability, but I suggest are profoundly different things. The first special case is bankruptcy, in respect of which my submission to you is that it is not to be treated as a species of arbitrability. If anything, it is an issue of admissibility or inadmissibility of claims, and only for a certain period of time, that is to say, while the bankruptcy is pending. But it is a different and in most ways a broader issue which has to be addressed in a comprehensive and clear fashion, but as a standalone issue. The second special case is ACMEA. You know the decision of the European Court of Justice last year, which held that an arbitration agreement in an intra-EU bilateral investment treaty was, I quote, incompatible with certain provisions of the Lisbon Treaty. It has been suggested that the consequence of this decision is to lead to subject matter inarbitrability. If I were allowed to speak to that topic, which I am not, as I'm professionally involved in cases which raise it, I would suggest very respectfully that the European Court did not spell out what is to be done as a result of the incompatibility, forgive me, that it saw. Now, before I leave you, the last matter which I wish to address very briefly has to do with the law applicable to subject matter arbitrability. And the most straightforward way, perhaps for me to spell out my thoughts, is as a series of propositions. Proposition number one is that the primary control of validity of an arbitral award belongs to the legal system and to the courts of the seat of the arbitration. Proposition number two is that, as I mentioned earlier, subject matter arbitrability is a notion different and distinct from the capacity to enter into an arbitration agreement and from the validity of an arbitration agreement, either substantively or in terms of form. And this is plain from Articles 34 and also 36 of the ancestral model law. Proposition number three is that the model law specifically entitles the controlling court to apply its own law to the question of subject matter arbitrability. See Article 32, Paragraph 2, Subparagraph B, Roman 1. Again, this treatment is different from the choice of law, or indeed laws, in the plural, that may apply to the validity of an arbitration agreement. Proposition number four, it must follow that by submitting to arbitration seated in state X, the parties are to be understood as having intended for arbitrability to be governed by the law of that state. That legal system is the one most closely connected to the arbitral process, and arbitrability is an aspect of the validity of that process. Proposition number five, it must also follow that other legal systems do not have a sufficient connection to regulate the issue of arbitrability, at least at that stage. Because if they did, this would have been spelled out in the model law. Proposition number 6. Nevertheless, other legal systems may come to have a sufficient connection. They may come to have such a connection if, and I stress, if an arbitral tribunal is brought to them for recognition or enforcement. That follows from Article 36 of the model law and the corresponding provision, which is Article 5, Paragraph 2A of the New York Convention. Proposition number 7. Until an award is brought for recognition or enforcement in states Z or Y, it would be speculative for an arbitral tribunal sitting in state X to forecast how the courts of states Z or Y would assess the question of arbitrability. Let me put it differently. If under the law of state X, the tribunal is bound to hold that a dispute is arbitrable, it would be remiss in its duty to produce a valid award if it were to hold that the dispute is after all not arbitrable by application of the law of states Z or Y. Now, with this, I come to the end of my intervention, disembodied as it was. I'm grateful for your indulgence and your patience, and I leave you in the hands of my more learned and thoughtful colleagues on the panel to critique my submissions. Thank you.
Thank you, George. See you later.